and developing case law. At this time, all participants are in a listen-only mode. Later, we will conduct a question-and-answer session, and instructions will follow at that time. If anyone should require assistance during the program, please press star, then 0 on your touch-tone telephone. As a reminder, this program is being recorded. I would now like to introduce your host for today's program, Mr. Mike Flanagan. Please go ahead, sir.
Thanks. Hello and welcome. I'm Mike Flanagan, partner and chair of Foley's food industry team, and I'm pleased to welcome you to the Newsfeed quarterly web conference series. Today's program will focus on all natural claims, an overview of the regulatory regime, developing case law, and related class action litigation. Joining me today to provide their insights are two great speakers, Nate Beaver and Michael Leffel. Nate Beaver is a partner in Foley's Washington, D.C. office and is a member of the firm's government and public policy and FDA practices and a member of our food industry team. Nate's practice focuses on the representation of manufacturers whose products and activities are regulated by the Food and Drug Administration, and he regularly advises clients on issues affecting food, food ingredients, and dietary supplements. Nate was recently named a BTI 2012 Client Service All-Star, the only food and drug lawyer in the U.S. who was awarded this distinction. Michael Leffel is a litigation partner with Foley. He's the chair of Foley's Class Action Working Group and a member of our Appellate Practice Group. Michael has represented clients in more than 100 class actions across the country and in 14 cases before the United States Supreme Court. He regularly defends clients in cases involving allegations of unfair and deceptive trade practices arising from their marketing and advertising practices. Before I turn the presentation over to Nate, I'd like to go over a few housekeeping items. This program will last approximately 1 hour. A copy of the slides from the program can be obtained by clicking on the printer icon in the bottom right hand of your live meeting screen. Live questions will be taken at the end of the program or can also be asked during the program itself by clicking on the Q&A tab above. We will apply for 1 hour of CLE credit after the web conference. If you'd like to receive CLE credit and haven't already provided your state and bar number to us when you registered, please forward this information to zrahim@foley.com. As noted, today's program is being recorded, and it'll be available on our website after the program. For audio assistance, please press star 0. Now, I'm very pleased to turn today's presentation over to Nate Beaver.
Thank you, Mike, and welcome everyone. I'm going to be focusing primarily on the regulatory regime associated with natural claims, and that involves both the U.S. Food Administration as well as the United States Department of Agriculture. Let me just give a quick overview on the topics that I'm primarily going to be focusing on today relating to natural claims. The first is that we do see that consumers actually value natural claims, that there is a real perception, a positive perception of natural claims with respect to food products. The second is that the U.S. Food Administration has not established a formal definition of natural. The United States Department of Agriculture as well has not established a formal definition of natural, although they do have ongoing rulemaking that I will discuss. Each agency, however, does have informal policy and guidance on how they regulate natural claims. Recently, we're seeing significant class action suits for both natural as well as all-natural type claims. In the absence, though, of specific guidance from the agencies, what we're expecting to see is that courts may be forced to fill in the gaps where agencies thus far have been either unwilling or unable to provide specific guidance. Consumer value with respect to natural claims. Despite the lack of regulatory definition, consumers clearly do value and seek both natural foods and ingredients. U.S. retail sales of both natural and organic foods rose nearly $39 billion in 2010, an increase of 9% over the previous year and 63% higher than 5 years earlier, according to market research publisher Packaged Facts. There's also continued growth is predicted nearly a little over 100% between 2010 and 2015 to $79 billion. So despite some of the uncertainty, or at least regulatory uncertainty, with the use of the term natural here, I think there is a real understanding that there's a positive perception from consumers for both natural as well as organic type foods, and that as a result, despite the recent expansion of significant litigation in this area, we expect that food companies and food manufacturers are going to continue to pursue claims such as natural for their products, despite some of the potholes that may crop up along the way. An example here is FritoLay. Beginning in 2011, FritoLay announced that nearly half of its products will be made with all-natural ingredients, including their Lay's potato chips, Tostito tortilla chips, and their Sun Chip products. Filed under perhaps no good deed goes unpunished, in December of 2011, FritoLay was sued over natural claims for both its Tostitos and Sun Chips products. This was related to the use of GMO ingredients in the corn products that are used, and we'll touch on that a little bit later on. All right, now I'm going to focus on FDA's guidance relating to natural claims. As I stated, FDA has not established a formal definition through the rulemaking process. So unlike such claims such as healthy, low sodium, fat-free, for example, which do have regulatory definitions that can be found in the Code of Federal Regulations, there is no formal definition of what natural means, or at least what FDA thinks natural means from a formal standpoint. In a 1993 preamble on nutrient content claims, FDA offered an informal policy language in the preamble, which is merely informal in guidance, but they said that natural means, quote, nothing artificial or synthetic has been included in or has been added to a food that would not normally be expected to be in the food. Now, except as to flavors and colors, however, FDA has not defined or issued any further guidance regarding the terms synthetic or artificial. Thus, products with added color, synthetic or artificial substances, or artificial flavors cannot be called natural. Beyond that, however, there really is a wide variety of other types of ingredients that the answer is not so clear on what FDA's position is. Let's talk a little bit about how we got to where we are today. In February 2006, the Sugar Association requested that FDA undertake rulemaking to establish a definition for natural. In August of 2006, FDA provided an interim response to the citizens' petition, saying it was unable to reach a decision on the petition, citing competing agency priorities and the limited availability of resources. And to date, it has not issued any substantive response to this request for rulemaking. In July of 2008, in response to a meeting between FDA and the Corn Refiners Association on whether the term natural can be used to describe high fructose corn syrup, Geraldine June, who is a staffer in the Food Labeling and Standards staff at the Center for Food Safety and Applied Nutrition, issued a letter after this meeting. Ms. June stated that FDA would not object to the term natural, whereby enzymes are fixed to a column by the use of a synthetic fixing agent called glycerol dihydride, so long as the agent does not come into contact with high dextrose equivalent cornstarch hydrolysate. This essentially outlined a position by the Food Labeling and Standards staff that so long as synthetic components did not come into contact with the ingredients being made here, and so long as there were no synthetic ingredients which were present in the final product here, that FDA was not going to object to the term natural with respect to high fructose corn syrup. However, as I'll talk about, both the courts as well as FDA to some extent have disclaimed this letter, calling it non-binding. In June 2010, several natural litigation cases involving high fructose corn syrup were stayed while the judges requested an administrative determination from FDA as to whether high fructose corn syrup qualified as a natural ingredient. This occurred in both the cases Hulk v. Snapple as well as Coyle v. Hornell Brewing Company. In essence, the judges in both these cases stayed the cases and requested that FDA go through an administrative determination process to allow the agency to weigh in on this issue before the courts did so. In September 2010, however, FDA responded to this request to the judges, making essentially 4 points. The first point was a timing issue. They essentially said that resolving the issue through the rulemaking process of whether high fructose corn syrup is natural would require opening a rulemaking process, which in FDA's opinion would likely take 2 or 3 years to complete, and thus from the perspective of this ongoing litigation in the judge's docket, it simply couldn't be done in a timely manner for FDA to be able to provide particular guidance to the court on this issue. They also pointed out that priority food safety matters were currently occupying the resources FDA has available for public proceedings on food matters. Many of you may be familiar with the multiple rulemakings that are currently undergoing with respect to the Food Safety Modernization Act, and in fact FDA has said that they expect many of these proposed rules to come out in the very near future. At the time FDA was writing this letter, they were beginning that process, and certainly from FDA's perspective was the highest priority in terms of rulemakings that they were undertaking. Third, FDA responded that consumers currently do receive some protection in the absence of a definition of natural, because FDA requires that all ingredients be declared on the food's label, and thus here consumers will know from a label if a product contains high fructose corn syrup or any other particular ingredient that would be required to appear on the ingredient label statement. Finally, FDA said the most relevant statement of the agency's views is that comes from the preamble language in the 1993 rulemaking, and specifically said that the Geraldine June letter is deemed to be an informal communication and does not provide a binding agency determination. Based on this particular response, as well as the FDA's current focus and priority on Food Safety Modernization Act issues, it really does appear that no rulemaking on natural will be forthcoming anytime in the near future, despite requests both from the courts, industry, and others that this be undertaken. All right, now I'm going to transition slightly to FDA's enforcement of natural claims in the past. In the past, FDA enforcement of natural claims has been relatively limited. During the 10-year period between 2001 and 2011, there were only 3 warning letters which cited natural claims. In August of 2001, with respect to a product, Oak Tree All-Natural Lemonade, it was cited for an all-natural claim when it contained potassium sorbate. Another one of their products, iced tea, was also cited for containing citric acid. Notably, this warning letter also contained a number of other labeling violations. For example, a color additive was not declared and citric acid was not declared. In August in 2001, FDA also cited a manufacturer of canned chopped tomatoes that had labels bearing the claim all natural, but listed calcium chloride and again citric acid as product ingredients. FDA stated in this warning letter that the addition of these ingredients preclude the use of the term natural to describe this product. There were again a number of other labeling violations, including a fresh packed claim, a healthy claim, and a sodium-free claim that FDA cited as part of the warning letter. Then in August 2009, a manufacturer of a cheese ravioli and lobster product had labels, again, that stated all natural ingredients, but then listed some synthetic substances in the product ingredients that led, again, for FDA to issue a warning letter here. Note that the warning letter did not specifically indicate what the synthetic ingredients were here. But again, other labeling violations were also noted in the warning letter, including HACCP violations as well as an ingredient statement. So between that decade of 2001 and 2011, we saw that FDA was citing natural claims very rarely, but when they did, it was always in concert with a number of other significant, generally manufacturing GMP-type violations that were also included in the letter. In 2011, however, we saw really a significant shift in that before there had been 3 over a full decade. In 2011, we saw that FDA issued 4 warning letters citing natural claims. The first was for a lime juice product cited for natural claims because the product had sodium benzoate, here a chemical preservative, and again, other labeling violations were noted, which included GMP and processing violations, as well as allergen labeling and unapproved drug claims. In July of 2011, a manufacturer of a blueberry bagel products were deemed misbranded because the label used the term all natural when they were manufactured with infused wild dry blueberries that contained potassium sorbate. The label also made the claim no preservatives, and we saw that the warning letter also included GMP violations as well. In August of 2011, a natural lemon juice manufacturer was cited for a natural claim because the product had sodium benzoate and sodium bisulfate, both of which FDA noted were chemical preservatives. Again, also seeing HACCP and GMP violations in that letter as well. Most significantly, though, in November of 2011, FDA issued a warning letter to Alexa Foods for roasted red potatoes and baby portobello mushrooms solely for making an all-natural claim. FDA noted that the product contained disodium dihydrate pyrophosphate, which is a synthetic chemical preservative. But the really most significant part of this warning letter is that it's the only violation that was cited by FDA, and FDA deemed a natural claim, which it believed was violative here, as significant enough for the issuance of a warning letter in the absence of any other claims. Although no warning letters yet have been issued for 2012, I saw that just last week FDA issued an import alert against an Israeli berry juice manufacturer, citing, among other things, a natural claim when it contained sulfur dioxide. In addition, the product also failed to bear a percentage juice declaration. So I think comparing the period from 2001 to the present, essentially, it really does appear that FDA has increased enforcement here and increased the significance of natural violations to the extent that a single violation can result in a warning letter, and at a minimum is more willing to review and cite such claims such as these. Also significantly, what we're seeing is plaintiffs' attorneys are citing and sometimes even including these warning letters in complaints in some of the class action litigations that Michael is going to talk about in just a moment here. Now just to transition a little bit as well to touch on the USDA requirements with respect to natural. FSIS policy on natural contained in the Standards and Labeling Policy Book was established in 1982. Keep in mind, again, this is not a formal definition that has been established through regulations, but is guidance that USDA has provided for some time. It states that a natural claim may be used in the labeling of meat and poultry products, which are regulated by USDA, provided, one, that the product does not contain any artificial flavor or flavoring, coloring ingredient, or chemical preservative, or any other artificial or synthetic ingredient. And two, and significantly here, because this is really a significant departure as compared to FDA's guidance on this issue, the product and its ingredients cannot be more than so-called minimally processed. And USDA has stated that minimally processed can include things such as smoking, roasting, freezing, drying, and fermenting, as well as separation like grinding meat, separating eggs, and pressing fruit. But notably, it does not include solvent extraction, acid hydrolysis, or chemical bleaching. If a product is more than minimally processed, it can be labeled as all natural if the ingredient would not significantly change the character of the product to the point that it could no longer be considered a natural product. So, for example, it must be qualified in the label, but an example could be all natural except for dextrose, modified food starch, etc., something along those lines. Now, with respect to the rulemaking process, in September 2009, FSIS issued an advance notice of proposed rulemaking concerning the use of the term natural in labeling for meat and poultry products. This was a continuation of USDA's December 2006 request for comments on natural claims. In that advance notice of proposed rulemaking, USDA said essentially, after considering the comments it received from the December 2006 request on natural, it found that the comments demonstrated that there was a lack of consensus as to either the general or common understanding of what the claim natural means to both the industry and the public, and also in the approach that FSIS should take to address the issue. So to some extent, FSIS was really throwing up their hands here, saying that there's no consensus on what it could be or what it should be. I guess notably, there's been nothing further on this particular rulemaking since 2009. Now, of course, many of you may be familiar with the USDA process, which, unlike FDA, requires that products and product labeling undergo a review and approval before that labeling can be used in the marketplace. So we're not seeing, and at least I'm not aware of very many cases where class action suits have been filed against natural products which are regulated by USDA, but I think this is really for two reasons primarily. The first is that because USDA requires the review and approval of labels, we see many less natural claims because of this process. And second, because the definition is more limited with respect to minimal processing of products, there really is a smaller category of foods that can clearly qualify for a natural claim under the USDA requirements. Now, just to touch on briefly alleged ingredients, when you look at the enforcement actions that FDA has provided, many of the ingredients, or at least some of the ingredients cited by FDA, may seem relatively straightforward as not being natural, in the sense that typically what we see are chemical preservatives being cited. However, many of the ingredients which have not formally been questioned are now appearing in lawsuit complaints. These include, for example, cocoa processed with alkali, maltodextrin, chicory root fiber, as well as inulin, and GMO-derived products, including soy and corn products. In addition, much of the focus has shifted to not simply the ingredients themselves, but how they have been made. Plaintiff attorneys have taken a very narrow view and are applying regulations of other agencies and even standards the companies themselves have affirmatively stated. So in summary, from a regulatory standpoint, neither FDA nor the USDA appear willing at this point to invest the resources that would be required in order to go through the rulemaking process to actually establish definitions on the term natural. So in the absence of this regulatory guidance, the courts, we think, may be forced on a case-by-case basis to weigh in on these issues. We're seeing litigation in this area is increasing, and plaintiff attorneys are becoming more savvy and clearly are looking for quick settlements with companies with large pockets. I think that leads quite nicely into Michael Leffel's focus on some of the litigation aspects, and with that, I'm going to turn it over to Michael.
Thanks, Nate. I think that gives us a good understanding of the regulatory side of things, and what I'm going to focus my discussion on is the consumer class actions that arise in this area, sort of where the battles are taking place, what are the issues, what's happening in these cases. I know many of you have a great deal of a significant amount of experience, I should say, with class actions, probably more than you want. Some of you I know I've talked to and you know about class actions but haven't had much experience. And I'm not going to go into all of the details about a class action, but clearly the main issue is that when an individual goes in and has a claim because they've purchased, Snapple, for example, which is in one of the cases, the individual damages for that person, even if they bought a lot of Snapple over a 3-year, 4-year, or even a 6-year period, because some of the claims at issue have 6-year statute of limitations, still that named plaintiff's, or that individual's rather, damages are going to be very small. The problem in class actions, of course, is that when you aggregate all those individual claims over a 6-year period and look at millions and millions of bottles of Snapple being sold, you're looking at a lot more exposure. So there are special rules that apply, obviously, for when you can get a class certified and when you can proceed as a class action, and that's one of the big areas for battle in these cases, and it's a very significant battle. We're going to talk about all of those details in a little bit, but first I wanted to touch on why is this area so hot right now. I think that as Nate was saying, there's obviously a lot of reasons based on what's been going on with the FDA and based on what's been going on in marketing about all natural products that has brought attention to this area. But I think a lot of it started, not started, but certainly it grew much more rapidly after a series of cases about the preemption defenses that were brought as defenses of these claims in the beginning. And the Hulk v. Snapple Beverage Corporation case that Nate talked about is an example of that. The plaintiffs had claimed that Snapple falsely labeled the beverages as all natural, but the plaintiffs claimed they weren't all natural because they contained high fructose corn syrup. And after waiting for the FDA to provide some guidance and not getting guidance from the FDA, the case, of course, proceeded in the district court. And the district court dismissed the claim as impliedly preempted by the FDA regulations governing natural flavors and the labeling of juices. When the case got up to the Third Circuit, they took a very different view and reversed, saying that there was no clear and manifest intention to preempt state warranty and consumer protection laws governing beverage labeling. Now, since that time, a number of courts have reached that same result, and I think that you see, because there's been no FDA action in this area, there is very little validity to the preemption defense. Now, that doesn't mean that you can't raise preemption in all cases. Depending on what the claims are, and if they're looking specifically at the labeling, you may be able to raise a preemption defense, but in large part, plaintiffs' counsel have been able to get around those issues. Another reason why this area is so hot right now is frankly, again, we've covered some of these, the new focus of the FDA, particularly with a lot more actions being filed lately. There's obviously more focus in advertising on natural claims, and you're also seeing a large number of copycat cases. And we see this not just in these kinds of all-natural class actions, but in all class actions. If one plaintiff lawyer in California has success, another plaintiff's lawyer in Florida is going to see that and think, well, I can pick up the package, I can read the ingredients, I can look at the all-natural claim, and I can just basically copy the pleadings that I've seen in other cases, even if it's a different product. And we're seeing a large number of those cases copied, not just in California, but in other parts of the country. But obviously the focus is in California because that's where you see a lot of these cases brought. And one of the reasons you're seeing some more cases in this particular area in California is because of the view that the pleading requirements are looser there, that it's easier to get a class certified there. A few years ago, the big battle in front of the California Supreme Court was in the in-rate tobacco 2 cases, which many of you may be familiar with, where they essentially decided what the standing requirements were under the new Proposition 64 for unfair competition law claims in California, and basically said, look, the named plaintiff has to prove that he or she has standing. He or she doesn't have to prove that the rest of the class has standing in order to proceed. We'll get to whether they get a class certified in a minute, but that sort of broke new ground in California. More recently, in the Kwikset Corporation case versus Superior Court, the case involves claims about whether the product was made in the USA. It relates to what we're talking about here today because the court said there is standing, even though the person who purchased some locks that were advertised as made in the USA when some components were assembled elsewhere, even though that he couldn't prove that he paid more for the locks than he would have paid for other locks or that the locks were defective, he was still injured because he alleged that he would not have purchased these products but for the fact that he believed they were made in the United States. In that same way, plaintiffs' counsel are bringing these all-natural claims, and as they get more sophisticated, they're saying, I wouldn't have purchased this product unless I thought it was all-natural. Even if there's no complaint about any sort of bad health effects or the fact that it isn't as healthy as they thought it was, it's just enough that the claim was made and they didn't get what they bargained for. Now, I will say a quick note about the Kwikset case. It's not all bad for defendants. In that case, the plaintiffs were not able to pursue a restitution theory for recovery, but they were able to proceed on their claim for injunctive relief. But it gives you a little flavor for why these cases are so hot in California right now. Now, understanding, we've touched a little bit about the types of claims involved, but I want to talk a little bit about plaintiffs' theories for recovery. They're testing out a lot of different theories right now, which is no surprise because this is a relatively new area of the law for plaintiffs, class action lawyers anyway. But they break down into four main categories as I see them. I mean, the first is just common law, good old-fashioned misrepresentation or fraud claims. They will make these allegations from time to time and try to recover, but they're not their favorite because there's a lot of case law out there that says with fraud claims in particular, you've got to show reliance, and reliance is typically individualized, and once you have individualized issues, as we'll talk about in a little more detail in a second, then you typically can't get your class certified. So one of their other favorite areas is state consumer protection laws. These can be Unfair Deceptive Trade Practices Acts or the Unfair Competition Law in California. Some states have 2 or 3 different acts that are very similar but all provide for individual private causes of action. And the key here is that typically they are broader or, should I say, easier to recover under these statutes than it is under common law fraud or negligence, in part because of this question of reliance. A lot of states have interpreted their state statutes to not require pleading reliance in order to recover under their state consumer protection acts. A third area is warranty claims. It's not the kind of warranty you think about when you go buy a car and you get a 3-year, 50,000-mile warranty. This warranty is the kind of warranty that you may have, or I should say the kind of advertising you may have on the box. The plaintiffs are basically saying, look, when you say this is all natural, you are guaranteeing that this product is all natural, and therefore that's another area where they can recover. One of them, even though that allegation sounds exactly like the allegation for a State Consumer Protection Act claim, plaintiffs' counsel sometimes like to proceed under this theory because there's some case law out there that suggests that reliance is not a requirement for a warranty claim as well, and so it's another area where they can try to pursue a claim. Finally, unjust enrichment theories, or really quasi-contractual theories in general, plaintiffs will come in and say, you advertised it as all natural. What I got wasn't all natural. It's unfair for you to benefit from that, and they'll try to proceed under that theory as well. There are some defenses, particularly to the unjust enrichment claim, that there are basically a contract for purchase here, and you typically cannot recover under these quasi-contractual theories when there's a contract for purchase, but nonetheless, it's a very popular area for plaintiffs' lawyers, a very popular theory for them. Let me talk for a little bit about the types of products involved. I mean, I won't go into great detail, and most of you are familiar with them, and Nate's covered some of them, but I really wanted to just give you the idea that it's every product under the sun right now. I mean, it's beverages, like the high fructose corn syrup claims. It's cooking oils and corn chips where you've got genetically modified organisms. And if you think about that for a second, with so much of our corn genetically modified these days, if every product that has corn in it can't use an all-natural claim because it's genetically modified corn, you can see, get a glimpse anyway, of how widespread these claims could be. But you're also seeing them against cereals and bars, against pasta sauce, butters, cookies. If you're a fan of the Real Housewives series, even Bethany cannot escape here. Her Skinny Girl Margarita Mix was sued because she has preservatives, even though the Margarita Mix was advertised as all natural. In addition to these claims with just all natural allegations, there are still claims about the health benefits, either that they're not as good for you as they say, or they actually have some negative health side effect. Now, those are more classic claims, I think, that we're all used to before we got into this all-natural world. And they're very similar, but they have differences. I just wanted to point them out. You see things like a very large settlement that Dannon ended up paying out for its Activia yogurt because they were advertised as having certain digestive benefits. Turek versus General Mills was a case where General Mills prevailed, but the allegations were that the product had a negative impact or a lack of a benefit, a health benefit from non-natural ingredients, which was, again, inulin derived from chicory root, as Nate's talked about earlier. So those kinds of cases are still out there, and they have a lot of overlap to the all-natural cases, but some of the issues are very different because you're going to deal with those health care claims. Well, let's talk for a second about a little overview of some of the things I'm going to cover next. Once you're in one of these class actions, what are the key issues? What are the defenses? Where are you going to take your stand? And, obviously a lot of it is going to vary considerably on the specific facts of your case. But I sort of break things down here in the discussion to three main battlegrounds, and they're not necessarily surprising, but we'll talk about some of the things that are of interest right now. And the first is just challenges to the sufficiency of the claims. The next battle line, if you're not successful there, is typically challenges to the plaintiff's attempt to get a class certified. And finally, in one way, shape, or form, actually getting to the merits of these cases. So let's first talk about the sufficiency of the claims. As most of you know, when the United States Supreme Court came out relatively recently with its Iqbal and Twombly decisions, it sort of put a new framework on pleading standards and dispensed with the view of many courts before then, where you would just look at consider conclusory allegations and whether there was any possible way for the plaintiffs to prevail. And the Supreme Court in these two cases, and certainly as interpreted by the lower courts, has made clear that, look, when you're looking at a complaint, you're not going to be able to rely on legal conclusions or conclusory statements. You've got to allege facts that support your claim, and those facts have to demonstrate that it's plausible for you to recover. Not just that it's possible, but that it's plausible. So in the context of these all-natural class actions, you want to look at, did the plaintiff adequately allege causation or reliance, for example, depending on what the elements of the cause of action are? Did the plaintiff adequately allege any injury in fact or damage? I mean, for example, did they allege that they paid a premium for the beverage that was all natural compared to a similar beverage that they claimed was not advertised as all natural? In the Wright versus General Mills case in the Southern District of California, the court held, look, we don't think that you've adequately pled your claim. And it did so because the plaintiff merely alleged that they purchased or purchased more of or may pay more for granola bars that were advertised as all natural. And the court said, look, there's no economic injury there. You can't proceed. I will tell you flat out, there are a number of cases, particularly in California, that have come out the opposite on that same issue, but there are some decisions out there that will give a little harder look to the plaintiff's claims. I put in just to note the Weinerview Snapple Beverage Corporation case from the Southern District of New York. Even though it was granting summary judgment, it wasn't at the motion to dismiss stage, it granted summary judgment because of a lack of evidence of the purchase price or the premium paid. The named plaintiff was claiming that they had purchased Snapple back several years. They didn't have any receipts. They didn't have any evidence of what the purchase price was, and they didn't have any evidence that they had paid a premium. And the court said, look, I'm going to grant summary judgment for that reason. I put the I put the reference to the case in here, even though I'm really talking about the pleading standards, because I wanted to highlight for people something about class actions, and that is the traditional view is that you don't get to summary judgment type issues, even against the named plaintiff, until after you've completed class certification briefing. And in fact, in Weiner v. Snapple, that is what had happened. The court had denied class certification because of the inability to show causation on a class-wide basis. But if you have a clear-cut grounds for granting summary judgment against the named plaintiff early on, you can bring that motion before you get to the class certification battle. And if you're successful, I mean, for example, let's say that there's no evidence that the person made any purchase of the product, and they can't come up with any evidence. That may not be the best example, but it's an example. You can bring a motion for summary judgment before you even get to the class certification stage Some courts may object to that, but in many courts I've been successful in doing that. And if you take out the named plaintiff early on, then the court throws out typically throws out the rest of the class action right there because there's no named plaintiff to represent the class. That's an easy way to try to get out of a class action before you end up incurring all of the expense of discovery and briefing and argument on class certification itself. So that's why I dropped that in there, even though it is a summary judgment case. Much more recently, in fact, just last week, the Ninth Circuit said in the Korea versus Dreyer's Grand Ice Cream case, they upheld a dismissal of a claim against Dreyer's because the plaintiffs had not demonstrated that any reasonable consumer would be misled. I think it's interesting, I mean, it gives you hope anyway, that even in the Ninth Circuit, some of these claims may be thrown out early. And in that case, if you're going to say that this is your original vanilla brand right next to a note that says it's artificial flavoring, that the plaintiffs are not going to be able to prevail. So maybe there's some hope even in California these days. When you're talking about the pleading standards, one of the things you shouldn't forget in these cases is Rule 9b. With Twombly and Iqbal, I was just talking about the common pleading standards, but Rule 9b applies to fraud claims, and as many of you know, requires you to plead the fraud with particularity, the who, what, when, where, and how of the fraud. That Rule 9b standard typically applies in these all-natural claims under the State Consumer Protection Acts. Now, those claims, like I said, are often broader than fraud claims, but the key is whether the real allegations in the case are grounded in fraud. So even if it's not called a fraud claim, but it's under the State Consumer Protection Act, it may be grounded in fraud, and if they don't plead with particularity, then you may be able to get an early dismissal. And in fact, some of these all-natural cases have been dismissed in part for that reason. Well, what happens if you get beyond the pleading stage and you have the unfortunate duty of trying to defeat the plaintiff's motion for class certification? There are going to be a number of arguments you can make, and for time constraints I'm just going to focus on a few, but the primary argument in these all-natural class actions is the lack of predominance. In order to get a class certified, as many of you know, you've got to show that the plaintiff has to show, and it's clear these days that it is the plaintiff's burden to show this. You don't just, the tie doesn't go to the plaintiff. The plaintiff has a burden to show that this can be done on a class-wide basis. You've got to show that common factual and legal issues predominate over the individualized issues that you need to address. And in these cases, the most important issue generally is the need to prove causation and or reliance on an individualized basis. Now, I said before that in a lot of states, they have interpreted their State Consumer Protection Acts very liberally to not require a showing of reliance as an element of the claim. But the prevailing view, and that may be true in certain cases. In certain cases, it will be true. For example, if you have two competitors, they may not have to show that they relied on it. But the point is that in these consumer class actions, where the claim is that the individual consumers were misled and the individual consumers are trying to recover, the prevailing view is that causation is a required element, and in these consumer cases, that requires a showing of individual reliance. So even though reliance disappears on the front end as an element of the case, it comes in through the back door through the requirement to show causation. Now, that issue, is heavily contested by plaintiffs' counsel, particularly again in California. There are a number of courts in California that have tried to suggest that the in-rate tobacco 2 cases and other cases have dispensed with that requirement, but the prevailing view is you have to show causation, and that requires a showing of reliance, and that is a major obstacle for getting these cases certified. Some of the other issues, adequacy or commonality, are requirements to get a class certified. Commonality, particularly after Dukes v. Walmart, has frankly a lot of overlap with the predominance requirement we just discussed. But adequacy of the named plaintiff, are they going to be an adequate class representative? There's certain standards that they're required to meet, and sometimes you can hit a home run on something as easy as this. The Coyle v. Hornell Brewing Company case from last year. The plaintiff claimed that she had bought Snapple multiple times without knowing about high fructose corn syrup. Of course, she was outraged by that, but it turned out that she had signed a retainer agreement to be represented in that case several months, I think it was 7 months earlier than some of the purchases she was complaining about, and not surprisingly, the district court judge was very bothered by that, doubted her trustworthiness, thought she was subject to unique defenses, and therefore, as part of the reason for denying class certification, held that she was not an adequate class representative. This really highlights the fact that you should do your homework. I mean, we should always all do our homework, but when there's so much at stake in a class action, if you can get a class action defeated for one of these simple arguments like this, it's certainly an area you want to probe at during discovery, you want to probe into during discovery. It's certainly, you don't want to leave any stone unturned. Look, most of the time, plaintiffs' counsel, they're sophisticated. They learn from their mistakes. They learn from their colleagues' mistakes. They'll get around this some way, but sometimes they don't. And if you can get a case kicked out this easily, that'd be a real coup. Finally, let me just say about two other areas. One is damages. It can be a basis for defeating class certification if it's individualized. If there is sort of a mechanical formula that can be applied to the whole class, for example, that every time a granola bar is purchased, they're damaged 25 cents, and you just have to prove how many granola bars a particular class member purchased. That's formulaic. That's not going to be a hurdle to class certification. But if for some reason that is individualized, we don't know what the premium paid was, or they purchased at different times, or they purchased for different prices, or that's not a proper way, the formula isn't a proper way to calculate damages, then it can be a reason to defeat class certification. And what you're seeing a lot more of, particularly after a series of Court of Appeals decisions in the last couple of years, is a lot more expert testimony at the class certification stage, in particular with respect to how damages can be calculated, that will demonstrate whether they can or can't be done on a formulaic basis. And if they can't be done on a formulaic basis, it's another strong argument against certifying the class. Finally, let me just mention on the predominance or on the class certification challenges, the issues that arise out of choice of law battles. Plaintiffs typically have always wanted to start with a nationwide class so that you have a lot of exposure and risk. Typically, that they believe that will drive you to settle early if their case looks like it's proceeding. The fact of the matter is that it's becoming increasingly harder and harder to certify nationwide classes when the causes of action or issue are, for example, these state consumer protection statutes. They vary in subtle but very material ways, and a lot of courts have held that if you've got to apply 50 different state laws plus the District of Columbia, we can't certify that class because we won't be able to address all of these unique, or I shouldn't say unique, but all of these individualized legal issues in front of one jury trial, for example. Now, tactically, plaintiffs have tried to get around this. They've tried to either pick just large states and try to get a single state class certified. That's one way. The other thing that they've tried to do is to pick a single state flaw and say it should apply because, for example, the company's headquartered in California, the advertising emanates from California, and therefore California law can apply to the whole country. Now, the Ninth Circuit has recently rejected that in a case involving Honda. But there are other courts, for example, the District Court in New Jersey, who adopted a very similar analysis in a case against Mercedes, and for that reason certified the class. But that's one of the areas where you're going to get some battles these days. Let me talk very briefly, because they are going to be very individualized, but let me talk about challenges to the merits. Obviously, as I pointed out before, you can have challenges to the damages. I mean, how were they really damaged? Did they pay a premium? What proof do they have of that? You can have challenges on what we all think of as the real issue here, you know, whether the ingredients are natural. For example, maybe they were only processed. Does that not make them natural? Again, you're going to have very individualized battles on that, but that's where you can draw the line. And then I mentioned again the health benefits. If there's no harm to somebody's health that's provable, maybe their plaintiffs are contesting a lack of a health benefit and you have proof that it does provide a benefit, that may factor into their damages claim, and you can have a battle there, even in these all-natural claims where the heart of the matter isn't the health benefits, but it's another area to think about. Well, one question is, of course, what should you do given everything that Nate and I have talked to you about? First, not surprisingly, act before it is too late. You want to check your ingredients list. You want to check your suppliers. I mean, are there verification requirements or certifications that they are required to give? If you are a supplier and you're giving certifications and verifications, what are you saying? Are you making a full disclosure, or are you just saying we're all natural because, for example, you assume that high fructose corn syrup is all natural, or are you making a special disclosure about that? Do you have an indemnification agreement that covers these situations? If you have a supplier and they're telling you everything, they're certifying that everything is all natural and it turns out it isn't, do you have an indemnification agreement in place to determine who's going to defend this action or who's going to, how the costs are going to be shared? These are all things you'd want to do in advance. Check your labels and your advertising. I mean, it seems like it goes without saying, but with these cases, a new one being filed every week, it's worth it to take some time to review all of this. And even if you're not going to change your labels and advertising, at least you want to be prepared for what you might see, and you may want to prepare your business people for what they might see. But when you're looking at that advertising, you don't want to just look at your advertising for the product in question. You know, we talked about the allegations against Cassie just briefly. We indicated there were some things, claims against their bars. One of the issues in that case was that Cassie had on their website and in other places, here's our pledge. It wasn't a pledge to you, but it was basically, here's what we think natural products are. And the allegations were, hey, your products don't measure up to your own representations. So when you're looking at your advertising, don't just look at your advertising or your web presence relating to the specific product in question. Make sure that what you're saying about this product is consistent with what you're saying in your broader advertising and marketing campaigns. Finally, you know, simple, it goes without saying, I mean, if you can switch ingredients if you need to, and it's feasible to do so, you might want to do that. And certainly a number of companies have done that. Maybe there's a substitute that doesn't cost much more. If it's worth it to do that, it may be, you know, and maybe when I say is it worth it to do that, you should factor in there the potential cost of litigation and the potential negative publicity you'd get out of one of these lawsuits. But it may be worth it to make a change or change the labeling and make some additional disclosures that you think will prevent or at least provide you a better defense in case you face one of these cases. Now, finally, I'll say what happens if it's too late, you're already facing one of these class actions, and I'm sure you'll not be surprised coming from a group of lawyers, our advice is to consult experienced counsel. But I say that in particular in these class actions because they do have a life of their own. The discovery, the briefing, the types of arguments you may want to make, particularly early on in the litigation, can all be very different from what you would do in a normal individual action. And you want to work with counsel early to develop a strategy to avoid excessive litigation fees, costs, and exposure. There may be ways, for example, to limit discovery early on so that you're just dealing with class certification issues and do so in a way that greatly limits the potential cost and time for both your people internally and for your attorneys, and so their fees don't run up, so that you can get through this process as efficiently as possible. That's all I have for right now, and I think Mike is probably going to open things up for some questions.
We are. I know we're going to open it up for live questions. We have one I want to take first that came in through the Q&A line. And Nate, I think this is one for you. Is there any guidance anywhere as to whether stevia is considered natural?
Sure, that's a good example, I think, of the shift that's really occurred as a result of the litigation. Stevia, of course, is a plant-derived sweetener that in the past I think people would have looked sort of just glancingly at it and said, well, it's plant-derived, it must be natural. The short answer is that FDA has not specifically provided any guidance on this as to whether it is indeed natural. And of course, apart from not providing specific rulemaking on the definition of natural, FDA hasn't weighed in on any particular ingredients, whether they are indeed natural or not. The only guidance they, of course, provide on a case-by-case basis is through the enforcement process, where they say particular ingredients in their opinion do not meet it. certainly looking at the enforcement actions that FDA has taken, they've never taken any action against a product such as stevia or any analogous product that is plant-derived. So I think you can say, or at least I would say, that the likelihood of FDA enforcement action against products containing this would be very low. Now, what's different now, having looked at this litigation, for example, as I earlier stated, plaintiffs' counsels are now focusing more not just on the ingredients themselves, but how they are processed, how they are manufactured. And for example, one litigation, again coming back to the cashew litigation, they have cited both grapeseed extract as well as chicory root fiber, which is used to extract inulin, as being not natural because of the manufacturing process that they go through. For example, with respect to the grapeseed extract, they have said that it requires a number of, quote, excessive processes and synthetic chemicals that render the product no longer natural. Similarly, with respect to inulin, they talk about the process that it goes through, purification, modification, and other treatments to produce the ultimate product here. So, you know, the real unknown here is whether or not there's going to be seen as any merit to this idea that the manufacturing process should have some input into whether or not the product is natural. And of course, they have cited to USDA's definition of minimally processed as trying to sort of bootstrap that with respect to that. Now, of course, FDA has not at all bought into the idea or agreed with USDA that minimally processed is something that ought to be included as part of FDA's definition. But it's certainly one of the issues that, from a legal standpoint, is one of the reasons we're so carefully monitoring these cases, because, frankly, from a regulatory standpoint, there simply aren't good answers in this area.
Thanks, Nate. Another question has come in, and actually two overlapping questions related to GMO-based products. And the first question is, has FDA said that GMO-based products are artificial or not natural? And the related question that I think Nate and Michael, either one of you might be able to comment on, is how does the push for GMO labeling on front of packages affect suits involving natural claims? So, GMO-based products.
Michael, do you want me to take that, or you want to take a crack at it?
Sure. Well, why don't you start? You've got the first line on the first question, anyway.
Sure. You know, it is interesting that GMO has cropped up now in these litigations, because we are seeing some states, or at least pressure towards some states, enacting labeling requirements with respect to GMO products. I'm familiar with a bill in Vermont that's been proposed which would require GMO type label statements. FDA, of course, has looked at this issue when they first permitted GMO products and came to the determination that GMO labeling was not required. They essentially said, from FDA's standpoint, that there were no nutritive differences between GMO and non-GMO products, and therefore they weren't going to require it. This has been very there's been a lot of activity in this area from consumer groups and others who feel that and feel very strongly that GMO labeling should be on there, and we certainly see this push coming. I think even if the GMO labeling was required, it doesn't necessarily really answer the question of whether a GMO product is also natural. I do think, however, that if there is a determination that GMO products are not natural, in the absence of a requirement for GMO labeling, I think companies are just merely going to pull back on making natural claims rather than having some sort of GMO statement on the label. But again, the GMO area in terms of the litigation is a little bit different than some of the other cases we've seen. But as Michael noted, because of the prevalence of for example, GMO corn and soy out there and the percentages, the high percentages that exist in the market, it really could be a sea change if there's a determination that GMO products cannot meet a natural regulatory definition.
The only thing I'd add to that, and I think Nate's covered it, but obviously if there's a greater and greater push and you see some states starting to adopt these requirements to have labeling on the front, in those states it seems like, if you comply with the labeling requirements, you're going to have a little bit of a safety net, but it probably will increase the push in other states where there's no requirement to say, well, if you don't have it, that it's somehow deceptive. That's what the plaintiffs' counsels will argue anyway.
Okay. Michael, another one's come in for you, I believe. The question is, what are the average costs incurred by companies in defending against these legal claims, whether they win or lose?
I'm sure that's a lot of people's favorite question. Of course, it's going to vary widely. But let me say this. We've literally talked to clients who have gotten a phone call before the case was even filed from plaintiff's counsel, and they're just looking to settle on the cheap. And sometimes there have been settlements even before a case is filed. It may not be a class action settlement, but there's some sort of comfort in knowing that this case from a particular plaintiff's counsel who's active in this area has gone away. Obviously, the costs there are pretty low. What I've seen is it's really going to depend on the facts, and I don't mean to just brush the question aside, but, I've been involved in cases where at the class certification stage alone, we've already had 8 or 9 experts. We've had 20 named plaintiffs in a nationwide class who were deposed. And in a case like that, your expenses are going to be high. They're obviously, by the time you get to class certification, depending on the plaintiff's tactics, you're going to be talking about several $100,000 or more, depending on, again, the plaintiff's tactics. One of the things that we have done is to work with clients up front and set, a variety of different approaches. But one of the ones that I'm most fond of is to say, look, let's assess where are we going to be at each stage of the process, because we all know where the likely battles are going to be, as I've talked about. And if there's going to be a battle on the motion to dismiss, and there's going to be a battle on class certification, and there's going to be a battle on a summary judgment as to the named plaintiff, let's leave aside the big issues, the ultimate question of whether this stuff is natural or something, or a full trial. But what we'll do is set up a flat fee for each stage of that, maybe with some, things in there to address potential issues that nobody's predicted, a change in strategy from plaintiff's counsel or something. But what we can do is try to address those. So I hope that helps address the question a little bit, but it can vary so greatly depending on all of those different factors that I've addressed earlier. But one way to try to get a handle with your counsel, whether it's us or somebody else, is to see if they're willing to make that commitment of saying, look, up to this motion to dismiss stage and through this, we're going to come in at X, we're going to come in at Y up through class certification. That gives in-house counsel a way to manage some of those costs. And a growing number of firms, we're not alone, but I think we've had a great deal of experience at this, but we're not alone in offering those things, and I think it's something you should consider when you're looking at pricing these cases.
We have a couple of more questions in the Q&A written queue, but I know that we promised to also open it up the phone, so maybe we ought to do that briefly now to see if anybody's been holding for a question in that format.
Certainly, ladies and gentlemen, if you'd like to ask a question over the phone, please press star then 1 on your touch-tone telephone. If your question has been answered and you'd like to remove yourself from the queue, please press the pound key.
Nate, while we're waiting to see whether or not there are questions coming in that format, we have one question here. What is the difference between natural claims and organic claims?
Sure. That's a good question because, we do see a lot of overlap with respect to natural products and organic products, and I think in many consumer minds, there may not be an understanding of the difference between the two, but certainly from a regulatory standpoint, with respect to organic, there is a very well-established definition as well as standards for what meets the organic definition. Organic claims are actually regulated by the USDA, and they have set up a national organic program in terms of getting certified for organic ingredients. There are also then essentially tiers that you can make with respect to organic claims, which include 100% organic, which requires 100% organic ingredients, an organic statement which requires that 95% of the ingredients be organic, and then made with organic ingredients essentially, where you're permitted to list some of the organic ingredients, and that requires the product as a whole to be 70% organic. So generally speaking, the most significant difference is simply that with respect to organic, the claims and definitions are very clear, whereas with natural, as we've discussed, it's much more ambiguous as to those requirements. So although there may be not clear understanding of the terms with respect to from consumers, from a regulatory standpoint, it really is sort of night and day.
Are you showing anything in the queue from the phone?
I'm not showing any questions from the phone lines at this time.
Okay. Then I'll stay for a couple more minutes for the last couple of questions that are in the email queue. Michael, given the Dukes v. Walmart decision and some other recent decisions favorable to defendants in class actions, what are the biggest concerns for defendants in class actions?
Well, I think that, there's no doubt about it that some of the decisions from the Supreme Court and the Court of Appeals in the last year or two have been favorable to defendants and have made it easier to defeat class actions in jurisdictions that used to be a little more class action friendly. But there are still issues. Obviously there are still going to be cases where classes are certified, where it's difficult to defeat class certification. One thing on my radar screen anyway that I've been focused on the last few years, and the Seventh Circuit has breathed some new life into this, is the concept of what's called limited issue certification. The Seventh Circuit rather just issued a decision this year in a case called McReynolds v. Merrill Lynch that suggested or that approved certifying just a few issues in the case, but not the entire case, and then dealing with what individualized issues later. Now that often happens, as I said earlier, when it comes to damages, but it's been really argued by plaintiffs for some time that under, and I don't want to get too technical here, but Rule 23C4, which governs class certification issues, has been used by some courts, and the Seventh Circuit adopted this recently, to just certify some key issues. Maybe it's materiality, maybe it's causation, or maybe it's the defendant's scienter, and so we're just going to address that as a class because that's a common issue that predominates, and then once that's resolved, we'll let these individualized issues be addressed later. Now, I think there are a lot of problems with that, and the courts of appeals are certainly not uniform on that, but the trend does seem to be going towards permitting these limited issues to be certified. And what that means is, in the old days where you'd say, look, there are these individualized issues that can be treated, so we're never going to get to the question of whether genetically modified corn is natural. We just won't get to that. Now there's some suggestion by courts of appeals that, well, maybe these issues can be addressed on a class basis, and then we'll leave everything else, for example, like whether anybody ever even looked at the advertising about all natural, to be decided later. And that's an area where defense counsel should be aware of it, in-house counsel should be aware of it, and it's something, frankly, to be a little concerned about.
Okay, thanks. One final question. No, they keep coming. What I thought was the final question. Nate, the question is, what is the basis for saying citric acid is not natural? It's found in nature, lemons and limes.
Yeah, again, that's another good example. You know, I would say that this is an issue that plaintiffs' counsels have really, again, hammered in on. They've pointed out not only citric acid, but ascorbic acid and other things which, you know, do occur in nature, but can also be synthetically made. FDA, you know, FDA doesn't have a specific policy that ingredients which do exist in nature but can also be synthetically derived are not natural. But what we have to go on is really a single warning letter where citric acid was specifically indicated as being inappropriate for a natural claim. Unfortunately, it didn't come with any particular rationale. And FDA has not taken action against all such ingredients that can also be found in nature. You know, what I can say with respect to citric acid is in addition to being an ingredient that has been cited in the litigation, that it is an ingredient that FDA has specifically related to in one of their enforcement actions as being not natural. And I think what can be taken from that is, at least with respect to that particular ingredient, that FDA sees that as a synthetic ingredient.
Okay. And finally, with respect to disclosures, I think you both touched on the idea of modifying labeling or advertising to include additional disclosures. The questions come in, how would more disclosures remove a problem with an all-natural claim? What kind of disclosures? And Michael, I think this is something you've already touched on a little bit, but perhaps you can expand on that just a touch.
Sure. Well, I mean, again, and I'd hate to harken back to this, but everything here is going to be fairly fact-specific. But, I mean, let's take the Dryer's ice cream case I was just talking about that came out from the Ninth Circuit. It's a little bit different there, but you know, the point was the advertising said it's original vanilla, but it clearly disclosed that it had artificial flavoring. And that may be slightly different than our all-natural cases we're talking about, but I guess maybe the takeaway from it is that the courts will look at, you know, the entire package or the advertising as a whole and not just snip out two words and view them in isolation when it's deciding a case. I've had a large class action for a manufacturer recently where we had lost on an issue in the district court, and we went up in front of the Eighth Circuit. One of the reasons we had lost is the court had viewed these two words in isolation, and the Eighth Circuit said, no, you have to look at the advertising as a whole. You have to look at the sentence as a whole in context, and if you do that, this is not and cannot be misleading. So just, you know, given that kind of example, the types of things that you might be able to do is if you say it's all natural, but it has some explanation of, you know, I don't know what product you have, but if it's genetically modified or something else, and there's some disclosure about that, it may not ensure that you're going to win, but it may make it much more likely that you could defeat class certification. It may make it likely that you'll win because you're telling people what they need to know. Now, I understand, and I know Nate does too, that obviously for those of you who are using the phrase all natural in your advertising, clearly there's some belief that if you say all natural but it's got X, Y, and Z, there's a concern that that's going to undermine the all natural advertising. But I just think that you should look at what it is that you think could be challenged based on the challenges that have taken place already and your best guess, and say, is there a way I can address this with some kind of disclosure in my advertising that will if not completely inoculate me from claims, may help my cause a great deal and reduce my exposure. And I think that's the kind of disclosures that I'm thinking about that may help.
And, Michael, that would seem to be applicable equally to food ingredient companies who are selling to manufacturers and where the manufacturers are requesting these types of certifications as well.
Absolutely.
Good. All right, I think we're going to wrap it here. Because of the volume of questions, and they were all great questions that we got, we obviously went beyond our normal hour, but I hope you found it helpful. Needless to say, we invite you to contact either Nate or Michael if you have additional questions or would like more information on their particular topics. And we do greatly value and appreciate your input and feedback. So if you'd be willing, we'd appreciate it if you take a minute or two and complete the survey that you'll see on your screen at this point. So again, thanks for joining us, and we look forward to our next program. Have a good day.